incident I'm going to talk about occurred in March 2003, and it was a flight that went from Hong Kong to Beijing. It was carrying 120 people with 88% occupancy, and a 72-year-old man from China boarded the flight, and 2 days earlier he had developed a fever. He went to see a doctor the next day, the day before the flight, but no specific illness was diagnosed, and unbeknownst to him, he was already infected via his daughter with SARS. So on this flight there were 6 people per row, so 3 sets of seats separated by the aisle, 6 per row. He was on row 14, and that meant that he had 23 passengers in front of him or on the same row, and 88 passengers behind him. And over the course of this flight from Beijing to Hong Kong, he infected 20 other passengers and 2 aircraft crew with SARS. And the infection spread through the aircraft to passengers over 6 rows away from him. Just pause to think about how that fits in with the modern day 2 meter social distancing. It would tend to suggest that that might not be enough on an aircraft. And he was, in the context of SARS, the original super spreader, because contact tracing showed that, for example, 1 passenger on the flight was an official from the Chinese Ministry of Commerce, and a week later that Chinese official sat next to an official from Finland at a summit in Greece, not in Greece, in Geneva. That Finnish official subsequently died of SARS, and 5 other passengers on the flight infected by this one man also died of SARS. So, I mean, you know, we're talking, this was 17 years ago, but, and I think I have to emphasize that it was apparently quite an unusual incident in the context of that epidemic. It does seem, in general terms, that planes are relatively safe, because even though they're enclosed, they use what are called HEPA filters, whereby, although the cabin air is circulated, it consistently passes through these very sort of effective filters that are good at catching viral particles, including those that are the size of COVID-19. In fact, in recent times, since this pandemic has started, the HEPA filters have been tested against COVID-19 and proved to be very effective. So notwithstanding the use of the HEPA filters on board, this one individual spread the virus to at least 22 others. So it's unlikely but not impossible. And so the question I'm posing is, in that sort of scenario, would one of the other passengers be able to sue the airline from as a result of contracting the illness? So what do we know about Montreal Convention? A quick run through the basics. It's an exclusive cause of action. So if the facts of the case fall within the scope of the convention, and frankly any sort of injury or illness occurring on board an international flight is likely to, then it provides your exclusive cause of action. If you can't fit your claim within the framework of the convention, you have no claim at all. So that's a difficulty, but on the other hand, it is a qualified strict liability regime, so that any notions of fault or negligence, failure to exercise reasonable care, are legally irrelevant to the questions that the court has to determine under the Montreal Convention. The basic test you'll probably mostly be familiar with. It derives from the decision of the US Supreme Court in Sachs and Air France, and the test is that there has to be an accident under Article 17, which is an unexpected or unusual event external to the passenger, and it's that test has since been expanded upon so as to mean that it can't arise from the passenger's own internal or peculiar reaction to the ordinary operation of the aircraft. That secondary part of the test is derived from Barclays and British Airways, a decision of the English Court of Appeal. Breaking that down into its constituent parts, what the claimant needs to prove then is a bodily injury caused by an external event, and the qualities of that external event have to be unusual or unexpected. Pausing there, just standing back and thinking about factual issues, I think causation of the virus, of the infection, is likely to be the major factual hurdle that anybody bringing a claim along these lines is likely to face, because one has to consider what the prospects are of demonstrating that you actually caught the coronavirus from someone on board that flight, the specified flight, rather than in any of the other places that you have passed through en route to and in the airport, with all those many other thousands of passengers that are doing the same thing. That's clearly a major difficulty, but it's obviously not impossible with appropriate contact tracing, as was demonstrated by the Air China flight. They were able to demonstrate by looking at the number of people that had contracted it, where they had been, who they'd been in contact with, that this one individual, this one 72-year-old, was the point source of the infection. And it's not plainly impossible to imagine a similar scenario with COVID-19. So causation is going to be a problem, but it's not going to be impossible. And I would imagine this sort of case probably being a group claim if it was going to be brought, because obviously the more people you have that you can demonstrate were on the same flight and became infected, the higher your chance of proving that that flight was the source of the infection. What about bodily injury? To what extent can contracting coronavirus be said to be a bodily injury? You'll recall that bodily injury is the specific term used in the convention. It's not personal injury. And we know from many cases around the world, including a decision of the House of Lords that then was in this country, that pure psychiatric injury is excluded. There is this strange case from the Court of Appeal, the Sixth Circuit Court of Appeal in America, a couple of years ago, called Doe and Etihad, which suggested that if you have a psychiatric injury at the same time as a physical injury, that's now enough under the Montreal Convention. It used to be thought that the psychiatric injury had to be caused by the bodily injury. And those of you who are interested in this sort of thing, and I suspect that's just me in the entire Zoom conference, will have noticed that at the end of last year, the US Supreme Court refused the defendant airline permission to appeal against the decision in Doe and Etihad, which means that, at least at the moment, we have a decision of the Court of Appeal, one of the courts of appeal in America, saying that merely having psychiatric and physical injury at the same time is enough. A very heavily criticised decision academically, but there we are. But in the context of this question, what about an illness or the sort of symptoms that you get with coronavirus? The best we can do is look at what the House of Lords said in Morris and KLM. Morris and KLM was the decision about psychiatric illness. And I've set out in the handout, but I'll read it to you, a quote from Lord Hobhouse in his opinion, where he says, contracting an illness may amount to an injury depending upon the degree to which the illness departs from the normal. One would not normally describe a person who had a cold as suffering from an injury, but on the other hand, one would certainly describe someone who contracted a serious disease or condition, say AIDS or hepatitis, as having suffered an injury. So you've got a strange sort of, it's not really de minimis, but he seems to be saying that it all depends upon the severity of your symptoms, which doesn't do much for legal certainty, frankly. Quite where you draw the line is hard to say. I suppose what I would say is back in the real world, it's very unlikely that anybody with a few sniffles and a sore throat is going to be remotely interested in bringing a legal claim. So there's only where you reach a certain threshold that causes you to initiate a claim that you're likely to be thinking about these problems anyway, in which case you probably then satisfy Lord Hobhouse's threshold test for the severity of the illness. So I think we can probably safely say that a moderately serious case of COVID-19 is going to constitute a bodily injury, at least according to the House of Lords. Next question, is there an external event which is unusual or unexpected? The concept of the external event has been framed fairly flexibly by the courts. The unexpected nature of it has to be judged from the perspective of the passenger, not the airline. So you can't have the airline simply saying, well, we're used to this happening, therefore it's not unusual or unexpected. It must be borne in mind, though, that it's the objective, reasonable passenger in the claimant's position whose perspective is important. It's not, you can't simply say that you have a passenger who regards everything as unusual or unexpected. The Australian Supreme Court, in the case of Povey, held it had to be the objective reasonable passenger. I think that must be right. That only one of the links in the chain of causation needs to be the unexpected or unusual event. Often injuries or illnesses are caused by many different factors working in unison or sequentially or concurrently, but only one of those links has to be identified as the event. And in the deep vein thrombosis litigation, there is a comment from Lord Walker that the event can be continuous and unrecognised rather than having to be instantaneous and immediately noticeable. So looking in the present scenario, a circulating virus within the cabin might be enough rather than having to identify the actual cough or sneeze from the infected individual which started it all off. So, you know, all those things are in favour of the event of the transmission of coronavirus constituting an event. Is it unusual or unexpected? Well, I mean, I don't walk outside expecting to get the coronavirus, but I suppose it might be said that in the context of a global pandemic, merely contracting the illness that we all know is out there might not necessarily be regarded as unusual or unexpected. I mean, I can see how that could be argued both ways. I think what is clear, though, is that the mere fact that you contracted the illness or injury on board the aircraft is not going to be enough. And we have the great Matt Chapman to thank for that piece of law in a case called Ford and Malaysian Airline Systems, one of Matt's many triumphs in developing the law in this area, which was a case where the claimant suffered a reaction to the injection of a diuretic on board the flight. And it was argued that that constituted an accident. The Court of Appeal really struggled with it. I think basically said, well, it could go either way, but in the end decided that the mere fact that an otherwise normal injection was administered on the flight couldn't give it the necessary unusual or unexpected characteristics. In other words, the mere fact that it occurs on board a flight but would otherwise be unusual in other circumstances doesn't make it an accident. So it is not enough to say that I wasn't expecting to contract this illness on board the flight. What I would say to that is that there is this strange sort of vein of authority in the United States, and I often come back to the United States because it has more decisions on the Montreal Convention than any other. And because it's an international convention, it's permissible to look at it. They have a line of authority. It's not applied exclusively, but quite widely, that said that the relevant event has to fall within the sphere of aviation-related risks. It has to be something that's specific or unique or characteristic of travelling on an aircraft. The House of Lords in this country, the Court of Appeal in this country, rejected that line of authority, so it didn't form part of English law in slightly sort of meek terms, in a case called Morris and KLM. Morris and KLM went to the House of Lords on the question of psychiatric injury, but at Court of Appeal level, the court looked at what was an accident. And that was a case where a young girl was sexually assaulted when she was sitting next to another passenger on a night flight. And the Court of Appeal said that it didn't matter whether the risk was an aviation-related one, but said on the facts it doesn't matter in particular because we think this was an aviation-related risk. And the risk that they identified was the risk of being assaulted by being forced to sit in close proximity to another passenger, an unknown passenger, and with a 15-year-old girl with a peculiar vulnerability. And they described it as a special risk inherent in air travel. So you can see how you might actually use this aviation-related risk concept, albeit that it's not strictly part of the law in this country. You might use it to bolster a claim based upon COVID-19, because it might well be said that it is the very fact that you're stuck in a metal tube in close proximity with other passengers with recirculating air that makes contracting coronavirus more likely than it would otherwise be, certainly than it would be, for example, if you were outside in a crowd of people where we know the risk of contracting a virus is less than indoors. So I can certainly see an argument being created along the lines of that contracting it on board a flight is a particular aviation-related risk. I think, though, that if these sorts of claims are going to be brought, and I'm sure they will be, particularly in America at some point, the real battleground here is going to be looking further back in the chain of causation. In other words, not focusing on whether the transmission of the viral particles from one person to another is itself the relevant event, but looking at whether or not the steps taken by the airline to reduce or minimize the transmission can themselves constitute an accident. Because as I said, it only has to be one link in the chain that is the accident. And if prior to the transmission by that individual, the airline failed, for example, to comply with its own protocol on the transmission of disease, then it may well be that that could constitute the relevant event, which is unusual or unexpected. Now, when I wrote an article on this, probably only a couple of months ago, Michael O'Leary, he of Ryanair fame, was saying that there was no way on God's earth that his airline would ever fly with social distancing measures in place. He since has, I think, rowed back on that a bit, realising that if he doesn't, he no longer is going to be in charge of a viable airline. And I think as of last month, so since I wrote this as an article, the European Union Aviation Safety Agency, EASA, has published a very detailed protocol on managing COVID-19 on air transport. And the protocol, which you can find online, covers the entire journey, so through the airport, on the plane, and at the airport at the destination. But on the question of managing the virus on board the actual aircraft, that they've set out what they note is that at the time of writing last month, there hadn't been a single report globally of COVID-19 being transmitted on board an aircraft, which is interesting, but not many people have been flying, frankly, so maybe not that surprising. But what they've suggested in some very broad terms is a list of what might be necessary preventative measures, and I'll just read them out to you. What they include is an emphasis on hand hygiene, particularly before eating and drinking and after using the toilet, appropriate use of face masks. Then we have this lovely term, respiratory etiquette, which is a nice idea, but I'm not quite sure what it means, other than perhaps putting your hand over your mouth when you've got a cough. Limiting contact with cabin surfaces and minimising on-board service. They say relatively little about social distancing on an aeroplane. And you'll recall that, for example, if the 2 metre rule is to remain in place, 2 metre rule is applied in this country, certainly not across the globe. It tends to be more 1 metre in accordance with WHO guidance. But if it was 2 metres, for example, on an English air operator, then there has to be 2 metres in every direction, not simply left or right. And so you're not going to get very many passengers on a plane. The European Union Safety Agency guidance doesn't say very much about social distancing, other than it had to be considered. One line did make me smile, though, which is it does say airlines should put measures in place to avoid passengers queuing in the aisle of the galleys for the use of the toilets. I mean, frankly, good luck with that. Unless you're going to have some sort of booking system to use the toilet on board, I really don't see how that's going to happen. But these sorts of practical measures do illustrate quite how difficult it's going to be for airlines to put in place effective measures to reduce transmission on board. I think a bigger problem, going back to the legal argument, though, is that the House of Lords in the Deep Vein Thrombosis litigation said that a mere failure to act or a mere omission to act could not constitute an accident, because an accident had to be a positive event, and that an omission was effectively the antithesis of an event. There had been an earlier Supreme Court, US Supreme Court decision called Hussein and Olympic Airways, you may remember, where he was a passenger who suffered from severe asthma, and he was allocated a seat a short distance away from what was then allowed to be the smoking section of an aircraft, which frankly is, just seems like an entire lifetime away. But they had smoking sections of aircraft back then. I think it was an internal US flight. Anyway, he was put a short distance away from the smoking section. He asked to move. He was refused permission to move to a different part of the plane, even though other seats were available. And he then died of an asthma attack on that flight. And the US Supreme Court held that series of events, or that series of happenings, constituted an accident within the Montreal Convention. Now, the House of Lords refused to say that Hussein was wrongly decided. They regarded it as something more than mere inertia. In other words, they were able to say, well, that the positive refusal by the passenger crew the flight crew, to move the passenger in the face of a request was not merely an omission, but was rather part of a more complex series of events and omissions looked at together, which were capable of constituting an accident. So a bit of a fudge, because you could see that the House of Lords thought that it was the right decision on its facts, but they stuck to their guns on the question of mere inertia or mere emissions not being capable of being an accident. So in the context of the coronavirus, if airlines are applying the European Aviation Agency safety protocol, the question would be whether or not they did something which could be characterised as a positive act rather than merely failing to do something at all. And I think it's going to be case sensitive, but relying upon Hussein, which is obviously a decision of significant authority, albeit from a different jurisdiction, I think it would be possible to build a case based upon failure to comply with protocols which the airline purports to have in place. Very finally, the last scenario I want to consider is what is probably going to be the easiest case to win in this context, which is going back to those HEPA filters that I talked about at the beginning, the high efficiency particulate filters. If airlines are, at the moment, if you read into their press releases, they are luring passengers back on board in the context of the pandemic by reassuring them about the efficacy of these filters and how good they are at catching viral particles, including those as small as the coronavirus. So if, for example, it was possible to demonstrate that the aircraft's filtration system was not working, and that made a material contribution to contracting coronavirus, I think you'd have a much stronger case. And there is one decision which I managed to dig out from the annals of the US sort of district circuit case law called Diaz and Trans Brazil. It was decided under the Warsaw Convention, so the predecessor to Montreal, and what it was a preliminary issue hearing, so it didn't actually decide the airline's liability on the facts, but it did find that where a passenger had contracted pneumonia and later died due to the quality of the cabin air, that the defective filters on board the flight were capable of constituting an accident in principle, without actually deciding liability. So there you have it. Those are my sort of ruminations on a theoretical claim.
As we all know, the COVID pandemics led to a huge number of cancelled flights, and there are figures circulating in the region of 90% reduction in air traffic. And certainly, if I look outside my window where there's normally a plane every few minutes, and there's now one a day, if that, 90% seems right from my own personal experience. We've got similar amounts of cancellation of holidays, and with ongoing lockdowns and travel restrictions, cancellations still a major issue for the UK and the UK market, even though some of the near neighbours and holiday destinations are gradually opening up. Italy, Portugal, for example. But as things stand, we're not even allowed to leave the UK at the moment, let alone return. But talking about flights for the moment, under the denied boarding regulations, passengers whose flights are cancelled are entitled to refunds. They'd also be entitled to rerouting, but that's not really realistic at the moment. Passengers have been encouraged to accept vouchers instead of refunds, but for quite understandable reasons, passengers, including myself, have all pressed for refunds. What this means is you've got an airline industry where new bookings are down by 90%, and refund requests far outpace the number of new bookings being made, leading to absolutely massive cash flow problems for airlines. I mean, it's pretty clear why people would normally prefer to have a refund than a voucher. My own reasons were concern about how long the voucher might be valid for, also concern about the airline's solvency, and if you have a voucher thinking, oh, well, I can fly again in a year, do you know your airline's even going to be there in a year? Other issues about the vouchers not being valid for long enough, and concern you might not be able to use the voucher in time. So all of those reasons. But this leads to an irony, which is the more people like me who insist on a refund rather than a voucher, the more likely you are to lead to the airline going under, the very concern that led to people pressing for a refund in the first place. So it's basically a classic collective action problem. If everyone accepted a voucher, it would probably be okay, but the more people who don't, the more likely airlines are to fail. So all of these concerns have led many EU member states, particularly those with large airline industries, to call for an amendment to the denied boarding regulations to enable airlines to basically require customers to take vouchers in place of refunds where flights are cancelled, so really easing the pressure on the cash flow problems that airlines faced. And at first blush, that suggestion looks incredibly anti-consumer, because you'd be really reducing a consumer's rights from what they have at the moment. But interestingly, when you look at the small print of what these countries have proposed, it's not actually nearly as anti-consumer as you might think. In fact, it's maybe very pro-consumer, because what they were suggesting is, whilst the right to a refund would be taken away, while that happens, the voucher offer would be significantly improved. So they were suggesting that there should be a right for a reimbursement if you hadn't used the voucher by the end of the period of validity. So if you didn't take another flight, then eventually you would get your money back. And they were also suggesting that there should be some financial protection for vouchers, so that if the airline went under and couldn't honour the voucher, that you'd still get your money back. So what they were really proposing was some kind of very long delay in potentially getting your money back and allowing you to take another flight in the meantime. And I've had a number of flights that I would have been taking during this period, and I've insisted on a refund for all of them. But if the vouchers had been as has been proposed, I would have been happy to take a voucher, I think. And I imagine lots of other potential passengers would feel the same. So how did the EU respond to this? Well, they didn't accept the suggestion that that refunds should basically stop. And instead they made a recommendation, which is a non-binding non-binding suggestion, essentially, that the voucher offer be improved in the way that's been described, but still allowing people to ask for a refund instead. And their suggestion was that individual member states support airlines by guaranteeing the vouchers and clarifying that that wouldn't constitute state aid. So it really puts the onus back on individual countries and governments who have a lot of other competing priorities to underwrite a system of airline vouchers. And you might think that's not going to be particularly appealing for lots of countries to do. This is an area where we really have to watch this space, because it seems that a majority of EU member states are in favour of removing the right to a refund, and the Commission hasn't done what they wanted. So I suspect there are going to be more changes along the way. So watch this space, really. Well, what about packages? Well, this is similar to the extent that where the organiser cancels, the customer is entitled to a refund, and a refund in 14 days, which has been an enormous problem for lots of tour operators. there's a similar amount of pressure to change the rules so that you don't have a refund as of right, because there are exactly the same issues with cash flow. And in fact, there's a rumour that the UK government is actually planning to amend the right to a refund in the package travel regulations to allow vouchers instead, with some of the sorts of protections that the EU had suggested for airlines. So we really do need to watch this space to see what our government does about this. Now, at this moment, I'm going to try and do a PowerPoint. So I want everyone to curb their enthusiasm, because this is almost certainly going to cause my internet to break down, not just in London where I live, but everywhere. What I'm about to talk about is incredibly dry and technical, and does involve having to look at the wording of various regulations and directives. So I thought I would get everyone on the slide first with some nice pictures. Now, I was talking about packages and comparing packages with flights, and the important difference that matters for this is that under the package travel regulations, customers are entitled to cancel and to get refunds in certain circumstances when they cancel themselves rather than when the tour operator cancels. And if I can make this go forward one slide, which is always a bit of a challenge. Hang on, there we are. So it's Regulation 12 of the 2018 regulations. So this provides a lot of things about cancellation. The passenger can cancel at any time and get a refund, but the tour operator is entitled to charge cancellation fees, and these are allowed to be standard cancellation fees based on the time and how close you are to travelling, essentially. If you do that, it's incredibly common to see 100% cancellation fees for late cancellations, and there's very little that a customer can do about that, but the tour operator has to provide a justification for the amount of the termination fee if the traveller so requests. But what I'm going to talk about is Regulation 12.7, which is the one on your screen, because this gives the customer the right to cancel without a cancellation fee when you have extraordinary circumstances. So the reason why I've put the wording up in the slide is because, as ever, the devil really is in the detail. And I anticipate we're going to have a lot of squabbles in the courts about what is unavoidable and extraordinary circumstances that allow a passenger to cancel and get a refund. Because we know this has been happening an awful lot. We've had people cancel their own holidays before the FCO said you couldn't go to that place. And tour operators at the moment saying, no, we're not going to give you a refund. I think this is going to happen more and more, because we're going to probably have a situation soon where some packages can theoretically be provided, and the tour operator may well not want to cancel, but the customer may well not want to go on the trip because they've got concerns about getting to the airport, flying in a plane. They may be sceptical whether it's really true, as Michael O'Leary says, that that the air is as safe on an aeroplane as it is in an operating theatre. Or they may not be. They may be concerned about. They may be concerned about catching coronavirus while they're on holiday, or impacts on having to quarantine when they get back. So I think we're going to have a lot of people cancelling in circumstances where the trip would have gone ahead otherwise. So the question is, what are unavoidable and extraordinary circumstances? What does this cover? Well, unavoidable and extraordinary circumstances are defined in Regulation 2, and this is the definition that I've put on the screen. So, a situation beyond the control of the party who seeks to rely on such a situation, and the consequences of which could not have been avoided even if all reasonable measures had been taken. Now, our regulations are based on the directive, and the directive, in the substantive part of it, has a wording which is very, very similar to our regulations. But it's quite useful to have a look at the recitals at the beginning, because they say something about what this is supposed to extend to. And what it says in the recital is, unavoidable and extraordinary circumstances may cover ... significant risks to human health, such as the outbreak of a serious disease at the travel destination. And at the end, which make it impossible to travel safely to the destination as agreed in the contract. Now that last bit may only apply to the natural disasters, floods, earthquakes and weather part. But if you look at this, it seems to be that the directive is anticipating that a serious risk to human health could well constitute unavoidable and extraordinary circumstances. And this is a bit different to what Regulation 12.7 says if we go back there, because this talks about unavoidable and extraordinary circumstances which significantly affect the performance of the package or carriage of passengers to the destination. So this leads to the question, what does it mean to significantly affect the performance of the package? And the regulations themselves have a definition of package, which is a combination of certain travel services. And these are carriage of passengers, provision of accommodation, rental of cars, other tourist services. Now, where this gets us to is there's really a narrow or a wide interpretation of significantly affecting the performance of the package. The narrow definition means if you, notwithstanding the problem in the destination, if the plane is still flying, the hotel is still open, the accommodation is still going to be provided, and everything you've contracted for in the holiday is still going to happen, you could argue that performance of the package is not going to be significantly affected, even though the holidaymaker's experience on the package or enjoyment of the package might be. That would be the narrow meaning. Now, the wider meaning would be more like what it says in the recital directive, that no, the package in the sense of the holiday is clearly going to be affected very significantly by major security problems or illness in the resort. And that does mean the performance of the package is significantly affected, even if the individual components are provided, because the customer is essentially not going to get the benefit that they've contracted to from going on this trip. But there's a real tension there, and I think it's inevitable that we're going to have tour operators arguing for the narrow interpretation and saying, no, you've cancelled, the flight was still happening, the accommodation was still happening, the holiday was still happening, so you're not entitled to a full refund. What other guidance is there about whether the narrow or the wide interpretation is correct? Well, under the regulations, there is key information which has to be provided to customers at the beginning. And this sets out in summary their key rights under the regulations. And part of those are rights about cancellation and termination fees. So the first bit there is what is your right to cancel just generally, but that you may have to pay a termination fee. The part that I've put in italics is the bit about cancelling without a termination fee in exceptional circumstances. And let's see what it says. Travellers may terminate the contract without paying any termination fee before the start of the package in the event of exceptional circumstances. For instance, if there are serious security problems at the destination which are likely to affect the package. Now, I think there is a difference between that wording, which is supposed to be in easy to understand language, and the narrow interpretation of Regulation 12.7. Because if you had serious security problems at the destination, it would still be possible to provide the package potentially. You could still have the hotel open and everything. But it seems to me this is more the wide interpretation of what a significant effect on performance of the package is, because the holiday is not going to be the same if there are serious security problems, or perhaps the holiday is going to be dangerous. So there's definitely scope for arguing the wider interpretation here, particularly as the new regulations are supposed to provide an enhanced level of consumer protection over and above the old regulations. Talking about the old regulations makes me sound a note of caution, because the consumer's right to to cancellation under the old regulations was interpreted in quite an anti-consumer way, with the famous stroke notorious last flicker of hope test, which I've tried to illustrate here with a candle in the wind to draw together the Princess Diana theme from the first slide. But if anyone remembers, from the earlier package travel regulations, there was litigation about the extent to which a consumer could get a refund if they cancelled in circumstances where it looked like the package wasn't going to be able to be provided. And got two cases, Lambert and Travel Sphere and Clark and Travel Sphere, where the courts held so long as there was still a flicker of hope that the package could be provided, that if the consumer basically jumped the gun and cancelled anyway, they wouldn't be entitled to a refund, even if it subsequently turned out that the package got cancelled. So people who waited would get a refund, but someone who jumped the gun when there was still a flicker of hope wouldn't. And it's entirely possible that that the courts will construe the 2018 regulations in a similarly anti-consumer fashion, I think. So it really depends on this narrow stroke wide interpretation of regulation 12.7. If anyone's wondering, I Googled for a picture of narrow and wide, and this is what came up. I'm not sure quite what it is. I think it's something to do with bicycle gears, but anyway, it illustrates the point perfectly. And going back to holidays more generally, I wondered how to finish this off on the PowerPoint. And I was thinking of, we'll meet again at some point and the Queen and things. But actually, I thought it'd be much nicer to finish with a lovely illustration of a beautiful beach in what I think is the Maldives. So I'm now going to try and stop sharing my screen and see what happens. Look, that's worked. Isn't that amazing?
That Jack and Andrew have pitched their topics. Can I put a pitch for the topicality of this talk? If lockdown has had any effects, firstly, it's not done wonders for the general health and fitness of the British public, and secondly, it's made us all wish for and miss our cheap holidays to Corfu. So these two factors may well turn out to be powerful drivers for an increase down the line of elective procedures taking place overseas within the EU, and with it the inevitable uptick in clinical negligence claims. The aim of this talk is to provide really a basic roadmap for untangling some of the jurisdictional and applicable law issues you're likely to encounter in a run-of-the-mill EU clinical negligence case. This is obviously a very big topic. It's far too large to cover in detail in the space of a short talk. I have a more detailed handout which I'll send out to everyone at the end of this talk, and as ever I'm happy to discuss with any of you any specific issues in cases that you have as and when they arise. But the easiest way of dealing with this subject is by way of a worked example. So assume the following facts. We have a middle-aged male, UK national, domiciled in England, and he does what many middle-aged men would do in the grip of a midlife crisis, and he spends £4,000 on a racing bike and a full set of Lycra. Having watched the Tour de France, he notices that his calves compare unfavourably with Geraint Thomas, and he elects to undergo a cosmetic procedure for the insertion of implants into his calf muscles. The difficulty is he's spent most of his money on the bike, but happily finds that he can get a bargain cosmetic procedure if he undergoes it in Greece. The arrangements for surgery were discussed in England in a local clinic, and the contract was procured from the internet, but the surgery itself takes place in a Greek clinic. The surgery inevitably is a failure, and the sloppiness with which the procedure is conducted results in a suboptimal outcome, both cosmetically poor in appearance, permanent scarring, and a series of complications as well. And in this case, the causative negligence is the surgical procedure itself, rather than any pre-operative procedures. And the claimant wishes to bring proceedings in England in respect of clinical negligence of the surgeon. The surgeon in this case is a Dr. Armstrong, an admittedly unusual name for a Greek national, and claims in contract and tort are envisaged. The domicile of Dr. Armstrong at this stage is unclear. In addition to homes in Greece, the surgeon retains a home in London and also practices medicine in London. Now, given the uncertainty as to Dr. Armstrong's domicile, it's necessary to consider a number of possibilities. The first question for us, of course, is whether there's someone that we can sue within the jurisdiction. And there are a number of potential defendants. The first, most obviously, is Dr. Armstrong. In the event that he operates through the offices of a clinic in England, then that clinic also provides a possible defendant as well. The client may also have an alternative cause of action against Dr. Armstrong if there is an indemnity insurer in place. And finally, if the surgery is paid for by way of a conventional credit card, then he can also potentially claim against the credit card company in a Section 75 claim. So the first scenario, and simplest for our purposes, if it transpires that Dr. Armstrong is domiciled in England and Wales, then the client can bring a claim against him in this jurisdiction using Article 4.1 of the recast Brussels regulation. Article 4.1 states that subject to this regulation, persons domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. Article 4.2 reinforces the fact that rules of jurisdiction which apply in England and Wales will apply to Dr. Armstrong, even if he is not a British national, and in this case, of course, he's a Greek national. And in this fairly straightforward scenario, there are 2 points to note. First of all, Article 4.1 of the recast Brussels regulation has a rigid application. In other words, there's no residual discretion in the English courts to decline jurisdiction where it applies. The second is the fact that Dr. Armstrong is a Greek national doesn't prevent the English court from assuming jurisdiction, provided that he's domiciled in England and Wales. What about if Dr. Armstrong is domiciled in Greece, as is perhaps the more likely situation? In that case, the presumptive position under Article 4.1 is that he's entitled to be sued in the courts of his domicile, namely in Greece. But the rights under Article 4.1 aren't absolute, they are qualified, and in particular, Article 5.1 provides that persons domiciled in a member state may be sued in courts of another member state only by virtue of the rules set out in sections 2 to 7 of this chapter. And so we need to then look at the special jurisdictional rules under Articles 7, 8 and 9. And on these facts, whether Dr. Armstrong on his own can be sued in England and Wales depends on whether the cause of action against him is in contract or tort. One variance of that, though, is that if he provides services in Greece through a clinic which happens to be owned by an English registered company, then you can rely on Article 8.1 of recast Brussels 1. What that enables you to do is to use the English registered company as an anchor in which to secure a foreign domiciled defendant such as Dr. Armstrong in this jurisdiction. A potential danger with that route is that following the Court of Appeal case in Saber and Curie, at the stage of its jurisdictional inquiry, the court is entitled to consider the relative merits of a claim against an anchor. So if there is in reality very little basis on which to bring your claim against the English anchor, then that may not ultimately allow you to pursue the true defendant in this case, which is Dr. Armstrong. So assuming you don't have the benefit of an anchor in the jurisdiction and you're envisaging a claim against Dr. Armstrong in tort, then we need to look at Article 7.2 of Recast Brussels 1. And what that provides is that a person domiciled in a member state, in this case Greece, may in another member state, i.e. the UK and the English courts, be sued in matters relating to tort in the courts for the place where the harmful event occurred or may occur. Now in this case, while the operation took place in Greece, the consequences, namely the injuries and other losses suffered by the client, have been sustained in England. And so it seems very unlikely that an English court would accept jurisdiction on this basis because the harmful event is likely to be regarded as the place of the operation itself, namely in Greece. What about if you don't have an anchor and you're pursuing a claim in contract, which is very often going to be the case when you're dealing with elective procedures? Let's assume that just as the surgery itself was fairly sloppy, so too were the contractual arrangements in advance of the procedure, and that the contract doesn't make any express provision as to jurisdiction. Well, at that point, we need to consider Article 7.1 of Recast Brussels 1. And what that provides is that a person domiciled in a member state, so again Greece, may in another member state, i.e. the English courts, be sued A, in matters relating to a contract in the courts for the place of performance of the obligations in question, and B, for the purposes of this provision and unless otherwise agreed, the place of performance of the obligation in the question shall be, in the case of provision of services, the place in a member state where under the contract the services were provided or should have been provided. So to simplify that, in the present example, the place in a member state where under the contract the services were provided was Greece. So again, it's difficult to see an English court assuming jurisdiction under Article 7.1 either in this particular context. A further possibility, what if Dr. Armstrong actually submits to the jurisdiction of the English court? Assuming that proceedings are issued in England and validly served either by serving on solicitors within the jurisdiction or serving out of the jurisdiction, it's possible that through inadvertence, Dr. Armstrong will in fact submit to the jurisdiction, and he will do so either by failing to acknowledge service and indicating intention to challenge jurisdiction, or alternatively by entering a defence. So when you're dealing with poorly advised or unsophisticated defendants, you do at least have to consider the possibility of them inadvertently submitting to the jurisdiction. Further alternative is the possibility of bringing an Odenbright claim against Dr. Armstrong's indemnity insurer. So let's assume that Dr. Armstrong holds indemnity insurance with a Greek company. Section 3 of Recast Brussels 1 deals with jurisdiction in matters relating to insurance. And what Article 11 provides is an insurer domiciled in a member state may be sued in another member state in the case of actions brought by the policyholder, the insured or a beneficiary in the courts for the place where the claimant is domiciled. And Article 13.2 provides that, among other things, Article 11 shall apply to actions brought by the injured party directly against the insurer where such direct actions are permitted. So the crucial condition for being able to bring an Odenbright claim against Dr. Armstrong, or against his insurers, I should say, is that a claim, a direct action is permitted by the law applicable to the action. Now, all of us are familiar with bringing Odenbright claims in the context of road traffic accidents overseas, and that presents us with no difficulties because direct actions are permitted as a result of EU law, namely the 4th Motor Insurance Directive. But English law doesn't generally permit direct actions against insurers outside of the road traffic accident context. And it may or may not be the case that Greek law will permit a direct action in the context of a claim for clinical negligence. So in this case, you would have to seek expert evidence as to whether or not a direct action against an insurer is permitted by virtue of the local law, in this case Greek law. In the event that the direct action is permitted under Greek law, then you can utilise Section 3 of Brussels 1, and that will provide you with the relevant jurisdictional right to sue in England. So that deals with the jurisdictional side of things. Turning next to the question of applicable law. You've successfully overcome the jurisdictional hurdles. You've got a claim that's proceeding in the English courts against Dr. Armstrong. What is the law that's going to apply to the case? Firstly, if it's a claim in tort, you have to start by looking at Rome 2, and in particular Article 4.1, which provides that unless otherwise provided in this regulation, the law applicable to a non-contractual obligation arising out of a tort or daily shall be the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which the indirect consequences of that event occur. While Article 4.3 of Rome 2 qualifies that rule, it's very likely that in the basic facts of this case, the English court would apply Greek law to the claim against Dr. Armstrong, even if from a jurisdictional perspective, he can be sued in the English courts. Alternatively, if you're bringing a claim in contract, the applicable law rules are going to be provided by Rome 1. The material provisions of that are Articles 3, 4 and 6. These are fairly lengthy provisions. I've set them out in full in the handout for you to read at your leisure. But the basic position under Rome 1 is that unlike in tort, the applicable law in contract is, wherever possible, that which is chosen by the parties. Now, it's possible, and indeed in the run of cases, it's likely that an express choice of law is made in the contract, but where it isn't, the next consideration is whether it can be inferred with a degree of reasonable certainty, looking at the circumstances as a whole. It's only when the contract neither provides an express provision and the circumstances don't allow for the applicable law to be inferred from the circumstances as a whole that you then need to look at the fallback provisions which are provided by Rome 1. So in terms of the possibility of an implied nomination of the applicable law, the court can look at the circumstances as a whole, and there are bound to be a number of factors to consider in any case, in particular things such as the residence and nationality of the parties, the language of the wording of the contract, the currency in which the price is quoted and paid, will all potentially contribute to the court concluding that in this case it was envisaged that English law would be the law applicable to the contract. It's only when you don't have either an express or implied election as to applicable law that you then need to look at Article 4 of Rome 1, which provides a fallback position. And at that stage, Article 4 steps in to provide that the law of the contract should be the law of the country where the party who is to affect the performance habitually resides, or in the case of a corporation, where they have their central administration. So it's important to notice there that there is a difference being made and a distinction being made between the habitual residence of the party of performance and the place of performance itself, the latter obviously in this case being in Greece. The final cautionary point to note on this is that if Greek if Greek law does apply to this case, then by virtue of Rome II, limitation is also going to be governed by Greek law. The consequences of that, as Matt will explain very neatly in the next topic, are not altogether straightforward when Matt discusses the fairly recent case of Pandia. As I say, a lot of the detail in this talk is set out in the handout, and I'll follow up this talk by sending that out in a few minutes. Over to Matt, I think.
The wordy title for this, Rome II Regulation and Limitation, substance, procedure and the commencement of proceedings, is reflective of some of the complexities in this area. As I say, I'm going to speak to you about a fairly narrow point, but one that, as you'll see, gives rise to some very real practical difficulties. This talk is focusing essentially on two cases, both of them tried on a preliminary issue trial basis at the beginning of this year, back in the good old days when most judges, certainly in the High Court, had never heard of Skype for Business or other such horrendous modern innovations. So we were actually in a real courtroom, which I can barely remember it, but it did used to happen. The first case, as Thomas said, is Pandia against Intersalonica. I was instructed in this case by Victoria Cox of this parish. This case was tried, as I say, on a preliminary trial of limitation issues basis by Mrs. Justice Tipples in late January of this year. You'll see the citation for the judgment in the handout. The second case, which followed hard on the heels of Pandia, was a case called Perez against KBC Vesekaringen. This was tried by His Honour Judge Foster, again in London in the High Court, funnily enough in exactly the same courtroom around the first floor landing of the High Court building. His Honour Judge Foster sitting as an additional judge of the High Court in this case. Again, a preliminary issue trial of limitation issues. Tried this one over 4 days with quite astonishing levels of patience exhibited by the judge throughout, for reasons I'll tell you about over a drink sometime when we gather in person. Both cases raised similar issues as to limitation under the Rome II regulation. In Pandia, the claimant was unfortunately unsuccessful and subject to a pending, I don't know if Victoria is with us, but a still pending, as far as I'm aware, application for permission to appeal to the Court of Appeal. That will be the end of the claim, given that the limitation issue went the wrong way, we would say. In Perez, by contrast, although it raised, among a number of issues, the same issue essentially as arose in Pandia, the claimant succeeded on the limitation issue against all defendants as a result of some very lucky quirks of the Belgian law of limitation that have really nothing to do with the subject of this talk, and therefore I won't bore you with today. The defendant is not appealing the decision happily for the claimant in that case. At the start, I think I described a few minutes ago, I described the issues in this area as complex. But Mrs. Justice Tipples, who, as I said, was the trial judge in Pandia, wouldn't agree with me about that. Rather oddly, on day one of this preliminary issue trial, you might regard this as sour grapes on my part, she was sufficiently unaware of the Rome II regulation, what it dealt with, to ask at one point what it was. Didn't give you much confidence that she'd read the skeleton arguments in advance, and had asked us, quote, to go slowly with it. On day two, which is when she delivered judgment in the afternoon, she was describing the issue as very straightforward. You might regard that as a sort of implicit testimony to the clarity of submissions, or you may just regard it as judicial overconfidence. You can ask, I suppose, Victoria about that. What then was the issue in Pandia and in Perez? They were both Odenbright style claims brought by an injured person directly, among other defendant parties in Perez brought directly against an EU insurer, and on the basis of the direct cause of action, the direct right of action against an insurer that was in each case permitted by the applicable law. In Pandia, Greek law applied, and in Perez, Belgian law applied. The cases were dissimilar to this extent. Pandia was a very sad case, as most of them are, of course, of traumatic brain injury arising out of a road traffic accident in Greece, brought, as I say, against a Greek motor insurer according to Greek law. By contrast, Perez, following on from Tom's talk, was an overseas clinical negligence claim, sort of bewildering a variety of clinical procedures that were carried out in Belgium. And the claim was brought against the Belgian professional indemnity insurer of the relevant surgeon and indeed the Belgian clinic, pursuant, as I say, to Belgian law. And we all know, of course, from Keefe and Mapfre in the Court of Appeal, and more distantly from the Mayer and Groupama case, that Odenbright claims of this kind are to be characterised for applicable law purposes as claims in tort or delict, as the case may be. And therefore we look, as we know, to the Rome 2 regulation, as Tom has just told you. We look to Rome 2 for two things. One, and first, to identify the applicable law of the tort, and two, step two, and this is what these preliminary issue trials are essentially about, at a high level of generality at least. Stage two, once you've identified the applicable law, you look to Rome 2 to determine the scope of the applicable law, that is, the issues that the applicable law of the tort will deal with. And in very broad terms, and again, as Tom has told you, the process of identification, stage one, what is the applicable law, can be dealt with or answered by looking at Article 4 of Rome 2, and the scope of the applicable law is generally dealt with in Article 15 of the Rome 2 regulation. And in Pandia and Perez, there was no dispute whatsoever between us and the defendant insurers that the English court had to apply foreign, respectively Greek and Belgian law to the tort. Look to Article 4 for that. And equally, there was no dispute at all that Greek and Belgian law, respectively, would apply to limitation. And the reason for that is because that is made clear, again at a fairly high level of abstract generality, by Article 15H of Rome 2, which states that the law applicable will apply, and I quote, to the manner in which an obligation may be extinguished, and rules of prescription and limitation, including rules relating to the commencement, interruption, and suspension of a period of prescription or limitation. And in both Pandia and Perez, it was common ground that the commencement of proceedings interrupted limitation. It stopped the limitation clock from ticking, according to the Greek and Belgian law applied. So if you look to the Greek and Belgian civil codes, they would both tell you that the commencement of proceedings interrupted limitation, stopped the limitation clock from ticking. And it was also common ground, as part of the sort of factual background, the procedural chronology in these cases, that the claimant, via the solicitors, the two claimants, had conscientiously issued their CPR Part 7 claim forms within the relevant limitation period in each case. And the limitation period in each case, pursuant to the Greek and Belgian laws that applied, was significantly more generous than the 3-year limitation period that we normally allow under English law for claims of this kind. This is where the cases become more complicated, to the potential advantage of the defendants, because the procedural codes of Greece and Belgium respectively required that in order validly to commence proceedings under the procedural regimes in each jurisdiction, it was necessary not only to file the papers at court in a process that is not dissimilar to what we do under Part 7 in the Practice Direction 7A at paragraph 5.1, where you deliver your claim form papers to the court, and the court on the date of receipt treats the case as brought for limitation purposes on the day that the court office receives the papers for issue. So in Greece and Belgium, in order validly to commence, you don't just deliver the papers and have the court receive them and stamp them and file to that extent, but also, and inconveniently for the claimant, in order to validly commence proceedings, you also, under these procedural codes in Greece and Belgium, need to serve the claim form on the defendant. In fact, it's even more complicated than that, because in the Belgian system, and I think Portugal from vague memory has something similar, you have a sort of topsy-turvy, to our eyes at least, system of validly commencing proceedings, in which you first serve the proceedings on the defendant in a sort of draft form before you file them with the court. So it's the other way round to the way that it works under the CPR Part 7 procedure, the complete opposite to the way that we do things procedurally here. So back to the facts of the cases. You can guess what's coming next if you don't know already. You haven't looked at the handout. In Pandya and in Perez, the claimant solicitors entirely conscientiously issue a claim form via the court within the generous allowance that the Greek and Belgian substantive limitation period provides, but they serve the proceedings on the relevant insurer. In brackets, the relevant insurer had done what they always do, which they don't make life convenient for you by providing nominating a solicitor within the jurisdiction for service. They make you go to the trouble and expense of getting the papers translated and then serving them overseas. And the papers were, the claim pack in both cases was served within the procedural time limit, the 6 months that CPR Part 7 provides, but outside the, whatever it was, 5 years, it doesn't really matter, but the more generous substantive limitation period in each case. So you issue the claim form within the substantive limitation period. You serve it, reckon from the date of issue, within the procedural time limit that Part 7 of the CPR provides, but that date of service is outside the substantive foreign law limitation period. And in each case, and as something of a novelty, because I didn't think defendants were always taking these points years ago, but you know, any port in a storm, the you know, Waitmans or wherever on the other side, Keogh's, I think in one of the cases, take the point. And the defendants argued that in each case, the claims were time barred on a variety of bases. But what it boiled down to essentially was this, that first, the foreign applicable law required the valid commencement of proceedings in order to interrupt limitation. Second, the foreign applicable law required filing and service in order for there to be the valid commencement of proceedings as dictated by the foreign procedural code. And in these cases, in Pandya and Perez, the claimants had only issued within time, ergo they had not validly commenced proceedings in order to limit it, in order to interrupt limitation, and the claims were therefore time barred. Claimants' counter-argument, again ranging widely, but essentially boiling down to these propositions, that while the English court had to apply the foreign rules referred to in Article 15H of Rome 2, namely the rules relating, among other things, to the commencement interruption, it's really about the interruption of limitation, of a period of limitation. This did not require, while the English court is applying that substantive law of limitation, that did not require, so the claimants argued, the English court to apply foreign rules of procedure. In other words, the English court still had to apply its own procedural code that finds expression in our civil procedural rules. And the reason for that, that distinction to be drawn between substance and procedure, is because of Article 1.3 of the Rome II regulation, which, as you'll know, expressly reserves matters of evidence, but in this case what's important is it reserves not just matters of evidence, but matters of procedure to the law of the forum, that is the English court. And the English court applies the procedural code that finds expression in the CPR, and therefore it's to Part 7 of the CPR, so the claimants argue, that the English court should look in deciding whether or not the English proceedings applying foreign law had been validly commenced. And so the way it works, so the claimants argued, is that you look to the civil code provision where it says you need validly to commence proceedings in order to interrupt limitation, and that's the end of it. As long as you have complied with CPR Part 7, which is procedural, that is all the English court has to do. It doesn't need to get involved in the minutiae of the sort of mixture of substance and procedure that determines whether or not the case would have been regarded as time barred if it come before a Greek or Belgian, as the case may be, court. And that we argued in both cases flows essentially expressly from Article 1.3 of Rome II. And a good example of this, I mean, you can think of a sort of variety of sort of conundrums and difficulties that arise if the English court starts dabbling in the foreign procedural code. But an obvious example of this in the Perez case was Belgium, where you simply cannot apply the Belgian procedural code on the commencement of proceedings, where it does something completely opposite to what happens in England, in the sense that Belgium, you serve and only then subsequently file what we would call the claim form, the originating process. You can't do it that way in order to issue a Part 7 claim form. It works completely differently. Also, extensions of time. I mean, it's pretty common, particularly with the foreign process section being closed down, as it was at least recently during this period of lockdown. We've been applying for extensions of time under Part 7 or 7.6 of the CPR as a matter of necessity. How does that leave a service when it takes place beyond the substantive limitation period? Do we have to ignore CPR 7.6 when the English court is applying a foreign substantive law of limitation? And the argument for the claimants essentially is that you can't simply pick and choose the bits of procedure in the CPR that the English court is to apply or not, or to disapply at the convenience and instance of the defendant. The CPR is, as the Court of Appeal said in Wall and Mutual, it's a self-contained and exhaustive procedural code that applies to all relevant matters of English procedure. You can't tiptoe through it and apply and disapply bits of it as suits the defendant. There's relatively little authority on this dividing line between substance and procedure in this context. I should say that this substance procedure, substantive law and procedural law fault line runs through English conflict of laws principles. I mean, it was as much a, perhaps even more of a feature of the pre-Rome II law as it is under Rome II. But I mean, it's retained this dividing line, this fault line between substance and procedure survives Rome II as a result of Article 1.3 of Rome II. And again, at a fairly high abstract level, part of the argument for the claimants in Pandya and Perez was that the English court needs to give some meaning in this, as in other contexts, to Article 1.3. The English courts can't simply ignore the fact that they're applying their own procedural code. Article 1.3 must mean something. As you know, there are some sort of some cases, English cases, post Rome II, where substance and procedure has been looked at. In Wall and Mutual, there was the substance procedure issue looked at in the context of permission for expert medical evidence. And there are a few other straws in the wind. There's a case, as you probably know, fairly recently in the last year, a couple of cases actually on amendments to pleadings in the context of substance and procedure, and the English court applying its own procedural rules, but applying at the same time a foreign law substantively. There's also a similar discussion about the same substance procedure issue in a case about interim payment applications, where the English court is applying foreign law to quantum. But there had, prior to Pandya and Perez, been really very little, if anything, nothing actually in England at least, on the issue of proceedings and the application of a foreign law of limitation. There was a Canadian case, obviously not a Rome 2 case, but a Canadian case that was directly on point actually, which is referred to in the relevant chapter of Dicey, Morris and Collins, a case called Vogler and Shendroy, which was decided fairly recently by at an appellate level by a Canadian Court of Appeal, one of the state or provincial jurisdictions, the Nova Scotian Court of Appeal, decided in 2008. And in that case, in essentially along very similar, if not identical lines to Pandya and Perez, the Canadian court had decided, where it was applying the law of a US state, a foreign law, which required issue and service in order to interrupt limitation pursuant to the substantive, the procedural foreign law. The Canadian court, as I urged on the English court in Pandya and Perez, had found that the requirement of service as well as issue was a procedural matter that therefore the Canadian court didn't need to apply because it was applying its own rules of procedure. So a supportive decision, albeit a non-Rome 2 decision, but on the same, essentially in the same context. And Mrs. Justice Tipple simply sidestepped that altogether, dismissed it in a couple of lines in the judgment in Pandya on the basis that it was not a Rome 2 case, it was a North American case, and therefore was completely irrelevant to the proper interpretation of the Rome 2 regulation, end of. So she dealt with that Commonwealth authority in fairly succinct terms. There is some academic writing about this, which was exhaustively before the court, certainly in the Pandya case. In Dicey, Morris and Collins, the author of the relevant chapter there was essentially supportive of the claimant's argument, even on a Rome 2 basis, but the support was expressed, quote, tentatively or hesitantly, I think was the word that was used. So it wasn't the strongest support. However, there was significant counter argument, at least counter to the claimant's argument, academic authority in a monograph that was written by Professor Dickinson on the Rome 2 regulation, which came out, I think, within a year of Rome 2 being promulgated. It came out in 2008. And Professor Dickinson is nothing if not an expansionist when it comes to the reach of the Rome 2 regulation and the matters that fall within the scope of the foreign law. And in the monograph, he expressly and emphatically says that the scope of the foreign law of limitation will embrace, in the issue service scenario that we were looking at, questions about what it means validly to commence proceedings. So he was essentially supportive, and strongly so, of the defendant's arguments, and was taking a line. The reason he formed that view, and the justification for it, was that he took a line from the recitals to the Rome 2 regulation, which, as you probably know, prioritize, the defendants argue to the exclusion of everything else, legal certainty and predictability of outcome in the context of seeking the harmonization across the EU of the foreign law or conflict of laws rules. So it was thought that it made things easier if you simply applied the foreign law to everything, including what it meant validly to commence proceedings. Of course, the claimant's counter-argument is actually if you're dabbling in the procedural codes of the relevant foreign jurisdiction, it doesn't make things easier or more streamlined. To the contrary, it makes everything vastly more complicated. It extends the need for foreign law expert guidance and input. But the Dickinson monograph has been treated with extraordinary deference by English judges. I got a theory, a sort of a conspiracy theory as to why that may be. I happen to know that, no, I'm not going to say anything defamatory, Sarah, before you get worried. I think Professor Dickinson has lectured the Judicial College on private international law matters, and therefore his views on the topic are given a great deal of prominence, but I would say, of course, disproportionate weight and prominence. But again, you might regard that as sour grapes. And his views were adopted, I think, wrongly. And don't worry about what I think. Robert Weir, the great Robert Weir, thought the same. We both thought that the Court of Appeal in Wall and Mutual, which said at one stage that it was applying the views expressed by Professor Dickinson in his monograph. In fact, they weren't. They misread them. But be that as it may, because in the Court of Appeal in Wall and Mutual referred expressly to the Andrew Dickinson monograph, I think again that has given it a sort of weight and heft that it might otherwise have. And if you read the judgment in Pandya, as well as saying that everything is very straightforward, I think the reason why Tipples J regarded it as very straightforward is because Professor Dickinson said so, and essentially the support that she gains for the decision that she reached is found in the textbook. So there it is. I think this is, not only is it giving rise to issues and difficulties now, but it's likely to carry on doing so. And I hope, I haven't been looking at the chat, goodness, I see 23 comments. It may be that Victoria is busily, if she's still on the line, sort of tapping away, saying permission to appeal just refused. In which case, you can ignore all of this. We're going to have to learn to live with what we've got. But I maintain the hope that the Court of Appeal will, at some stage, have another look at this and will take an anti-Dickinson line on it for the reasons I've outlined. There we are. Thank you very much.
Claims against the MIB. You will all know that the MIB is our insurer of last resort, as it were. So where you have a road traffic accident and it's either an untraced driver or an uninsured driver, you make a claim against the MIB. Under the 4th to 6th motor directives, European directives, all countries have compensation bodies equivalent to the MIB, and they have deals between themselves. So where you sue, you would have, but for the directives, had to sue the, say, Greek Auxiliary Fund, and you would have to sue in Greece. You now sue the MIB in England, and they then get compensated by the Greek Auxiliary Fund. So they then seek recompense of anything that they've compensated you in relation to their Greek accident. So the MIB is our insurer's last resort, as it were. So if there's an untraced or an uninsured driver in an accident, road traffic accident, either in this country or somewhere in the EU, for the time being, you sue the MIB. And the regulations that you sue them under are the Motor Vehicles, blah, 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 Compensation Body Regulations 2003 regs. And is very mechanistic. So when you're suing the MIB, because it's a statutory body, it's not like a common law tort negligence type situation. You have to go through the hoops that the regulations set up for you. So every time I sue the MIB, I take the time to just look at the regulations again. It sounds crazy because we do it quite a lot, but actually because it has to be right and it's got to be done in a particular way, it does repay rereading. It's like every time you make a Fatal Accident Act claim, you take a deep breath, step back, and then you just go through it in a really mechanistic way. So regulations 12 and 13 are the regulations that you want. You need to check that you comply with with everything that's in those regulations. If you do, then you can make a claim against the MIB in this country, and it just makes everything very streamlined. You don't need to make a claim against the equivalent body in Greece or Belgium or Spain, wherever it may be. So you need to show on the balance of probabilities under regulations 12 and 13 that the vehicle that caused the accident that your claimant was involved with is normally based in the EEA, so in the European Economic Area. That has not troubled any of us for years and years and years under the regulations, but just recently the MIB seemed to be taking the point, you must prove that that vehicle was normally based within Europe. Of course, where you have an untraced driver, they say, haha, you can't prove that the car that your untraced driver was driving was based within the EEA because you don't know anything about that car. And I've had a number of cases where that's been a plank of their defence. So they said, you know, you can't show where that particular vehicle was based. Most recently, I had one in Corfu, I think it was, where they raised that as defence. And when you first read it, you slightly panic and you're like, crumbs, I can't prove where the car was based. But actually, on the balance of probabilities, if you get hit by an untraced driver in Corfu, it's probably going to be a car that's based in Corfu, unless someone has exported their car over to Corfu, hit you with it, and exported it back again to wherever they come from. So all things being equal, I think, unless there's some reason to believe otherwise, I think you assume that the car that hit you, even if it's untraced, was based in the EEA. So I think it's yeah, balance of probabilities, Tiggs is pointing out. Yeah, it's a worrying defence when you first see it. They're using it all the time, but you're just proving on the balance. The burden is on you, burden's on the claimant to show on the balance of probabilities that it was based within the EEA. But I actually think, although the burden is on you, there's a sort of presumption that if you get hit in a certain country, that the car is based in that country. Particularly where you're looking at Greek island, which is what I was looking at, because it's quite unlikely that someone's exported a car to there. But it's just something to watch out for, because those in relation to those countries that have a very significant traffic flow between them and a non-EU country, it's a possibility that the defendant might be able to bring forward evidence that shakes that assertion. So just bear it in mind, if nothing else, that if you get a defence in that says that, it's probably not right, so don't let it worry you too much. Because you know what the MIB are like, they take every conceivable point. So that's the first thing, the vehicle has to be normally based in the EEA. Secondly, the accident has to take place in the EEA. Thirdly, you have to have made a request for information about the insurer, because if the car that caused the accident is insured, you have to go against the insurer. And if you start a claim against the MIB and you subsequently discover an insurer, you then have to substitute that insurer for the MIB. Because as I say, they are very much a last resort. So you have to make a request for information. And it has to be either impossible to identify the vehicle, which you'll know pretty early doors, but you have to make reasonable efforts to do that, to go to the police reports, find out the police investigations, see what they did, see what was reasonable. Again, I had another case where my claimant, it was said by the MIB, did not cooperate with the local police in trying to find the vehicle. And they said, because you didn't cooperate with the local police in identifying the vehicle, it wasn't impossible to identify the vehicle, because you could have identified the vehicle if you had cooperated. My claimant in that case was in a coma for 2 weeks after the accident, and that's why they hadn't cooperated with the police. So again, as I say, it's another example of the MIB just taking every conceivable point and some inconceivable points. But that's a possibility that they could raise that as your lack of cooperation with local police being the source of your failure to locate and identify the driver. And yeah, it is harsh, and they are harsh, and that is their attitude to pretty much all claims that I've ever brought against them, certainly, is to take every single point. Thank you for that contribution, Andrew. I think if your claimant is dead, they're probably not able to cooperate with the police, and therefore it will be impossible to identify the vehicle. The alternative is that you can identify the vehicle, but you can't identify an insurer within 2 months of making the request. So you need to have made a request from the MIB to identify an insurer of your car then you wait 2 months. And this again circles back to what Stephen was talking about with limitation, that if, and I have been asked sometimes to draft particulars of claim where we're making a claim against the MIB, but we haven't requested information about the vehicle's insurer from the MIB more than 2 months before we have to issue the claim. As a matter of technicality, that's defective, that claim form, because you don't fall within Regulation 13 because you haven't requested information about the insurer, and they haven't found it impossible to find that insurer within 2 months. So you've got to bear in mind, if limitation is approaching, even if it's a defective request to the MIB, get something into the MIB that requests information about that insurer, because if you don't, you're not going to fall within the regulation. So there has to be a 2-month time lag between your request and the claim being issued. If you satisfy all of those points, so if the vehicle's normally based in the EA, if the accident's in the EA, if you've made a request for information about the insurer, but it's impossible to either trace the vehicle or trace the insurer, then you can make a claim for compensation as if the accident had occurred within Great Britain. And that wording of the regulations has given rise to a lot of heartache and angst. And again, I'm going to, yeah, Stephen's right, always email the MIB at the outset, even if you think you know who it is. It's better to check than it is to find out further down the line that you don't know who your insurer is, and then you're stuffed because you haven't made a request of the MIB. Yeah, I'm going to tread on Matthew's toes, because I know Matthew is as upset as I am about the way that the case law has gone in this, but we have to go through it. So issues arose under the regulations as to what the applicable law would be, because you're making a claim against an English defendant, but it's a creature of statute, and you're making a claim about an accident that happened in a foreign country. So what is the applicable law in relation to liability and quantum in relation to your claim for the road traffic accident? Well, we know from a case called Jacobs, which is a Court of Appeal case in 2011, that the law in relation to liability is the law of the country where the accident happened. So you're going to need to get a foreign law report that tells you what the law is on liability. So for example, if you've got a traffic accident in Spain, and you've got, and your client's an English client, they've gone to Spain and they've been hit by either an untraced driver or a driver that's not insured, you're going to need to get a lawyer, foreign lawyer, to tell you what the relevant provisions are on liability in that country. That will include the limitation periods. Some countries have very short limitation periods. Now, you don't need me to tell you that, but in the Spanish example, it's a year. The shortest one I think I've ever come across is the Dominican Republic, which is 6 months, which isn't relevant for these purposes because it's not European. But some of these countries have really short limitation periods. Often, if that's the case, then you can extend limitation, but you need to do that because you've got to comply with the foreign law in relation to liability. Now, in Jacobs, the 2011 case that I was talking about, they decided that English law applies to liability, but the foreign law applies to liability rather, but English law applies in relation to valuing the claim. So the value of the claim is done by reference to English law. Matt was then involved in a case called Bloy and Ireson in 2013, again, Court of Appeal case, again, a really sad case, as Matt says, they tend to be. It was a bus crash, lots of passengers, one of whom was a child very, very badly injured, and the child had a very large claim. In Lithuania at that time, they had a damages cap of 500,000 euros per accident. So if you applied the Lithuanian damages cap, the claimant was going to get a proportion of 500,000 euros, and the other passengers would get part of the 500,000 euros as well. And as I recall, I think there's an argument about where the costs came out of that as well, in which case, yeah, there was, in which case, you can readily see that if there was a 500,000 euro pot for all the claimants, and if there were half a dozen claimants making claims, and if all their costs were going to come out of it, the very badly injured child was going to get pennies at the end of the day. So if you applied the Lithuanian damages cap, it would be really very bad for the claimant, for the child. If you applied English considerations of quantum altogether all round, the child would get very significantly more, plus costs. I don't know whether that weighed on the court's mind, but they followed Jacobs and they found that the English considerations of damages would apply, and therefore the Lithuanian cap didn't apply at all. And so the child recovered an appropriate figure, as we would see it, to compensate for damages. Now, it's right to say that that's since changed, and the Lithuanians can't do that anymore, because in the 6th Motor Directive, the European Union provided that there should be a minimum compensation provided for of €1 million per victim or €5 million per claim. So you wouldn't get such a low cap, but you might still get a damages cap in, let's say, Lithuania of €1 million per victim. And sometimes that can be not nearly enough to compensate claimants. So we still have those damages caps in some European countries. But that didn't matter at that time, because both Jacobs and Bloy and Ireson told us that those foreign damages caps would not be applied in cases brought against the MIB in this country. And that was one of the great advantages of doing that. And we all advised our clients that they would have to prove their case in liability in the foreign law, but they would then have a claim that was valued under English law. That all changed in 2016. The Supreme Court heard a case called Marino, which we're all who act for claimants exceedingly bitter about, because the Supreme Court found that in a Greek case, although they accepted what was said about liability, and the foreign law does apply to issues of liability, but they rejected the decisions in Jacobs and Bloy, and they said that actually the whole lot is determined under that foreign law. So if Bloy and Ireson were to be heard today, that Lithuanian damages cap would apply and the child would be very badly undercompensated. In Marino, that was a Greek case, and there is a Greek damages cap. So quantum was determined under the Greek law in Marino because the Supreme Court said that they had to interpret the regulations as being consistent with the underlying directives. We needn't worry about the thinking behind it for these purposes. But Marino changes everything. It means that if you see previous case law and previous decisions prior to 2016 that were heard after Jacobs and Bloy, those decisions don't count anymore. And it's now the lower measure of damages. Might be higher if the foreign law is higher, but usually it's lower, and usually there are damages caps. So I've had Greek cases where I've had very badly injured claimants, and we have had to accept damages cap of, I think, €500,000, €700,000 in one case, which the MIB originally said included costs, and we fought that and pushed back on that. And actually they accepted in the end that the claimant should get the €700,000, I think, plus costs. But there is an argument that it should include costs. So Marino, a bit disastrous for those of us who work for claimants, but it does mean that those cases where you are bringing a claim against the MIB in relation to a foreign accident, you need to get evidence of foreign law in relation to liability, limitation, and quantum, because it's going to apply to everything other than procedure and costs, because costs are part of the procedural rules, which is the argument that we deployed to say, well, your damages cap doesn't include costs. But that's certainly something that's arguable, although we don't have any authority on it yet. So pretty bad news if you're out for claimants, actually, the Marino case. My one question, I suppose, at the end of all of that canter through, is whether or not we might, post-Brexit, decide to do something else with our regulations, because it's European law that underpins all of this. The motor directives underpin this, but actually we bring claims pursuant to the 2003 regulations. And once we Brexit, we can alter those regulations. And there was quite an appetite in the English courts at one point, prior to the Marino case, for trying to compensate claimants as if they had had accidents within this country, meaning that they would get the same measure of damages as we would give. I don't know, is the answer, whether or not we will tinker about with the regulations after Brexit. It's open to us to do that, but that will affect the entire jurisdiction in relation to the agreements between all of those compensation boards. And at the moment, because everything is so up in the air with Brexit, it's just impossible to tell where we're going to go with jurisdiction, applicable law, the compensation bodies and what they do with each other, and everything else. I think on that note, you've had a couple of hours, so well done, that I will leave it there.